Welcome to everyone, and we have well over 2,000 attendees with us today. My name is Dan Paliu, and I'll be your host and moderator for this session. I'm a partner in the Ottawa office of the Labour Employment Group at BLG. Thank you very much for joining us today for our second webcast in our series dedicated to helping you navigate the unique and complex legal issues related to COVID-19 and its impact on your workplaces. We recognize and appreciate that this is a very difficult time for all, and our goal today is to provide you with legal and practical insights that will assist you in developing a path forward for your organizations and your workforce. In the next 45 minutes, we are going to be exploring the top 5 key issues of concern to employers, including temporary layoffs, constructive dismissal, work refusals, employment insurance, and new statutory leaves. We have a broad and very diverse audience today, and it is our goal to answer as many of your questions as possible, which many of you submitted when you registered for this event. We see that we have organizations joining from across Canada, and we know that many of you have operations in multiple provinces and territories. So we've gathered some of BLG's labor and employment law leaders from right across Canada to answer your questions, and they will be taking a Canada-wide approach. For your information, our next webinar will be 1 week from today, and will cover many of these same important issues for employers, and will be delivered in French. Alors, avant de commencer, j'annonce que notre prochain webinaire prendra lieu la semaine prochaine, et cette session sera uniquement en français et traitera un éventail de questions importantes pour les employeurs. Also, for your information, today's session is eligible for CPD credits in many provinces, and also the presentation and other information will be provided to all of you in a follow-up email. We really want to make the most of our time together today, so we will get started now with our first topic, which is temporary layoffs. Our first speaker is Cliff Hart. Cliff is a partner in our Toronto office, and Cliff is going to walk us through the 4 key questions with respect to the very complex issue of temporary layoffs. So welcome, Cliff. I thought you could get us started by answering this question, which is, what are the differences between how layoffs are treated in a unionized versus a non-unionized environment?
Thanks, Dan. Layoffs have to be approached quite differently depending on whether they're in a union or non-union environment. In a unionized environment, the vast majority of collective agreements contain seniority, layoff, and recall provisions, and sometimes those provisions are very detailed, all of which mandate the order of layoffs and the accompanying processes. And even without detailed provisions, the concept of layoffs, the ability of an employer to lay employees off, is a recognized right in the unionized environment. This isn't generally the case in non-union environments, where in the absence of specific provisions in an employment contract or an employer's policies or established practices, layoffs can result in constructive dismissal claims when an employer essentially stops paying employees who are presumptively able to come to work. And Jen, I think, will be talking about that further. So going back to the unionized environment, the employer must ensure that any layoffs are undertaken in accordance with the provisions of the collective agreement. And so a collective agreement, the terms are essential, as there could be bumping rights or what's called super seniority protections for union stewards or representatives, which provide that the stewards are to be the last to be laid off, subject to having the skill and ability to perform the remaining work. And so in this environment, if less than a full complement of employees in the bargaining unit are being laid off, the failure to follow these provisions can result in grievances that, frankly, could otherwise have been avoided. One of the key pieces of advice we give to employers dealing with layoffs in the unionized environment is to have open communications with their union. Layoffs, even in the normal course, can be very complicated, and in the current environment, a union may understand the necessity of layoffs for the good of the employer, and the union will also understand the protections afforded to employees under the collective agreement.
Thank you. Now, a number of our attendees today have employees across many different provinces. Are they able to take a standardized approach to layoffs across Canada?
That's a common question we're being asked, Dan, from our clients, especially those with locations. It may be plants, it could be retail stores or restaurants in multiple provinces across the country. And so in general, the answer is yes, but there's several key caveats. So as we all know, employment law is regulated at the provincial level, and there is a lack of consistency between provincial employment standards legislation as it relates to temporary layoffs. And that could be the ability to do so at the front end or whether any notice has to be provided to employees. So there are specific requirements that employers should be aware of in each province. One way to break it down is to look at the approach versus the procedure. So let me explain that a bit further. The approach involves deciding whether to treat all employees in multiple locations in the same way, to lay them off, to continue benefits for a period of time, how the layoffs are to be messaged to employees and delivered to employees, mail, email, etc. And many employers, despite any provincial statutory differences, have decided to take a consistent or one-size-fits-all approach. The caveats, however, come into play in terms of the processes based on the unique provisions in the provincial legislation. For example, Alberta, which allows for temporary layoffs, a layoff notice must include a copy of the relevant sections of the legislation. No other province requires that. In Saskatchewan, there must be a notice of a temporary layoff, but most provincial Employment Standards Acts are silent on that. Of greater importance, significance is the distinction in the duration of temporary layoffs and when, by operation of the law, the layoff might become a deemed termination. For example, prior to the introduction of emergency legislation in Saskatchewan last week, temporary layoffs in that province were only up to 6 days. Quebec, on the other hand, allows for temporary layoffs of up to 6 months. And Ontario defines temporary layoffs of either 13 weeks in a consecutive 20-week period or 35 weeks in a consecutive 52-week period if certain payments are made by the employer. Take it up a notch, and even more importantly, employment standards legislation in several provinces has special and substantially more onerous mass termination provisions which kick in when a set number of employees are terminated within a specific period of time. In Ontario, for example, where 50 or more employees are terminated in a rolling 4-week period, the employer must provide the Minister of Labour and all employees with 8 weeks of notice or pay in lieu, despite the employee's years of service. And these obligations increase to 12 and 16 weeks where there's 200 or 500 terminations, respectively.
Thank you, Cliff. Now, we've been reading and hearing that many provinces have introduced brand new declared emergency leaves in response to COVID-19. What are those leaves, and is it open for employers to put employees on those leaves instead of laying their employees off?
Yeah, Dan, I'll outline the leaves generally first and then answer the second question. So several provinces have taken steps to pass emergency legislation to provide unpaid but job-protected emergency leave for employees in respect of COVID-19. British Columbia, Alberta, Saskatchewan, Ontario, Newfoundland, and the feds under the Canada Labour Code have all made amendments to introduce job-protected leaves in respect of COVID-19, but the eligibility rules and the duration of the leaves aren't consistent. For example, Alberta's leave is for a period of 14 consecutive days, although the minister has the ability to extend the length of the leave. The length of the leave for British Columbia, Newfoundland, Saskatchewan, and Ontario is generally for as long as the employee is eligible for the leave. What's also noteworthy is that New Brunswick has announced that it plans to make similar amendments, which are expected to be an unpaid leave for up to 15 weeks. And the Yukon doesn't have a specific leave, but it has a program that provides the employer a rebate of a maximum of 10 days of wages per employee to allow employees to self-isolate for 14 days essentially acting as a job protected leave. Dealing with Ontario in a bit more detail, tabled as part of Ontario's emergency response to the pandemic, the legislation provides job protection for employees in isolation or quarantine due to the pandemic, as well as those that need to be absent from work to care for children due to school or daycare closures or to take care of other relatives. This leave is retroactive to January 25th, which is the first date of the confirmed case of COVID-19. So going to your other question, Dan, one of the main questions we've been receiving regarding the Ontario leave is whether employers can place their employees on this leave. In our view, the answer is no. Importantly, this is an option for employees and does not and should not be considered to be an option for employers to force on employees. Employees who are entitled to take the leave under specific conditions can do so, but again, it's at their prerogative and not mandated by employers.
Cliff, when I'm talking to clients, what I'm hearing, the greatest challenge that they're facing is the unknown. It's the uncertainty as to how long these measures are going to have to be in place. So can you tell us, please, what happens in the context of temporary layoffs if all of this goes on longer than anticipated? And can you also focus a bit on the differences between what happens in a unionized and a non-unionized workplace with respect to these layoffs?
Yeah, Dan, obviously there is a fear of the unknown for all of us. But in response to your question, if the shutdown continues longer than initially expected, employers will be faced with some difficult decisions. So one might be whether to recall employees for temporary periods of time and then lay them off again to essentially restart the clock, which might be an option available to employers, but it may be costly to do so. The other is to face the risk of deemed terminations or mass terminations when provincial thresholds that I outlined before are met. And these are going to be hard decisions, but we suggest that employers start giving thought to that now. For employers who haven't yet laid employees off in Ontario, one thing to consider is the ability to continue to cover benefits or other payments in order to fall within the 35 within 52-week rule. This could provide additional leeway or a bit of a buffer for those employers. And importantly, for those employers who have laid employees off and have continued payments on a temporary basis to try and get into the 35 and 52-week rule, we're suggesting that employers strongly consider continuing those benefits because once stopped, those temporary layoffs may then automatically convert into terminations. What we're also hoping is that provincial governments will provide support to employers coping with these issues. Turning to unionized environments, collective agreements, like I mentioned before, are key, and they will apply. So some collective agreements will provide for employee elections, for example, whereby employees may, under the collective agreement, be given the opportunity to either retain their recall rights or receive what could be enhanced severance payments in the collective agreement. Most collective agreements will also contain recall provisions which address the order of bringing employees back. Unions, to put it bluntly, are going to be all over employers to get this part of the collective agreement right, because if employers recall, I'll call it the wrong people first, there's the real risk of grievances with potential significant liability. So collective agreements, unlike the non-union environment, have a set game plan for recalling employers, and we're recommending and urging our unionized employer clients to make sure that they fully understand and follow the terms of the collective agreement.
Thank you very much, Cliff. Our next speaker is Jennifer Fantini. Jennifer is a partner in our Vancouver office, and Jennifer is going to walk us through the issue of constructive dismissal claims. So welcome, Jennifer. I was hoping you could take us from a general point of view about what the most common constructive dismissal issues are arising from COVID-19 for employers.
Sure, Dan. So the most common constructive dismissal issues are arising in the context of employers implementing temporary layoffs and reductions in pay. Even though most employment standards legislation across Canada contemplates the ability to impose a temporary layoff, these will be viewed as a constructive dismissal except in specific circumstances. And so one of those circumstances is where there's an express term to lay off in the employment agreement. That's not typically the case. Another is where there is an implied term permitting layoffs in the industry. But again, in most cases, there is neither an express nor an implied term. So what you have is a situation where there is going to be constructive dismissal risk if an employer decides to impose a temporary layoff. In any event, we have seen employers moving ahead with temporary layoffs with that risk in mind as the best possible option when faced with the requirement to shut down operations or when faced with drastically reduced demand. Second, we're seeing large-scale reductions in pay being implemented, and that can be either across the employer's workforce or across large groups of employees. Sometimes this is with a corresponding reduction in hours, but not always. Sometimes employees' hours stay the same. Typical pay reductions that we're seeing are in the range of 10 to 30%, but we're also seeing more drastic cuts too, as much as 60%. Finally, there are a handful of other measures that employers are using to cope with the COVID-19 pandemic, which could amount to constructive dismissal. These include transferring employees to a different location, changing their work hours, or requiring them to work remotely. These types of changes carry less constructive dismissal risk than temporary layoffs and pay reductions.
Thank you, Jennifer. I noticed you used the word risk quite a few times in the last few minutes. How can employers mitigate the risks with respect to a potential constructive dismissal claim?
So Dan, yes, there are ways to mitigate constructive dismissal risk. And constructive dismissal risk arises really anytime the employer attempts to unilaterally impose a fundamental change to a term of employment. The first principle to recognize is that changes which are introduced on a temporary basis are considered less likely to amount to a constructive dismissal. And you might ask why this is. Consider a 30% pay reduction imposed over a 4-month period. While a permanent pay reduction of 30% would almost certainly amount to a constructive dismissal, when imposed on a temporary basis, say over 4 months, the impact to an employee's annual pay will be about 10%. And that's a number much less likely to trigger a constructive dismissal. So that is an important feature of this, is that a lot of these changes are being imposed on a temporary basis. Changes that are introduced on a temporary basis must be communicated as temporary, though, so the employee knows what they're accepting. And there are some challenges to that, which I'll speak to in a little bit. The most important way to mitigate constructive dismissal risk, though, is to seek employee agreement or consent to the change. Under normal circumstances, it would be very difficult for employers to obtain employee agreement to significant pay reductions. But these times are not normal, and most employees will understand the gravity of the situation and will want to preserve their jobs. We are hearing that employers are having high degrees of success obtaining employee consent to reduce pay, even drastic pay reductions, when this is considered a temporary measure to stay afloat. So a key recommendation then is to obtain consent to these fundamental changes in writing if possible. Down the road then, if the employee changes their mind and decides to initiate a constructive dismissal action, this documented evidence of consent will be crucial. And the final point is that when seeking consent, messaging is really important. It's recommended that employers explain the impact of COVID-19 on their specific business circumstances and remind employees that we're all in this together. It helps if you can tell employees that executives or senior people in the organization are also taking pay cuts and that the organization is making hard decisions to preserve as many jobs as possible. I know that for some employers, seeking consent will not be possible or practical. Maybe there's too many employees to approach, or there's a time crunch and they don't have time to provide employees with, a document that says, please accept or don't accept and seek legal advice if necessary. They don't have time to wait. And so in such cases, the pay reduction will be implemented unilaterally, which brings with it constructive dismissal risk. And so keeping the pay reduction to a smaller amount and for a shorter duration is recommended.
Thank you. Those are some good practical tips. Do you have you seen any other practical issues or challenges that employers are facing?
One of the challenges with introducing fundamental but temporary changes is predicting how long temporary changes will be necessary. And in this case, that's been an aspect of this pandemic that employers are struggling with. It's recommended that employers set out in writing an initial period for which the temporary changes will apply. And of course, you can make that subject to review and possible extension at that time. Employers should consider what to do if an employee does not accept a pay reduction on a voluntary basis. So there may be employees, the odd one, who will decide that they don't want to accept that pay reduction, even though it will help them keep their job. So in those cases, the employer needs to ask, will the employee be temporarily laid off? Will the employee's employment be terminated? Will the pay reduction be unilaterally imposed anyways on that employee? Deciding in advance how this will be handled is important in preparing a strategy. Finally, ensuring the most favorable outcomes for the employee when implementing temporary layoffs and pay reductions is something that will assist a good result in these cases. And what I mean by that is you as the employer want to put the employee in a position where they're able to collect EI benefits or have access to the new Canada Emergency Response benefit that my colleague Michelle Henry will be speaking about later. If reducing pay, consider reducing the employee's hours too if possible. The employer is going to be more likely to obtain consent if the employee is needing to work fewer hours for less pay. The employer can also consider the federal work sharing program where wage and hours reductions are being contemplated. To the extent that an employer can provide its employees with access to government benefits in order to supplement their reduced pay, this will smooth the process. Really, at the end of the day, the more an employer can keep an employee's income whole or as close to that as possible, the less likely it is that an employee will make a constructive dismissal claim.
Thank you, Jennifer. Our next speaker is Catherine Poirier, and Catherine is going to speak to us about work refusals for unsafe work. Catherine is a partner in our Montreal office, and we're thrilled that she could present with us today because she has particular expertise on workers' compensation and health and safety matters. So, Catherine, we've been reading a lot about work refusals in this context of COVID-19. Can you explain for us, please, what happens if an employee refuses to work and declares the reason as fear of COVID-19?
Well, actually, then, the right of work refusal for unsafe work will only be substantiated when the employee has reasonable grounds to believe that to carry out their work would put themselves or other persons in the workplace in danger. So the simple fear of being in contact with an infected person would most likely not be enough to constitute reasonable grounds for work refusal under applicable provincial legislation, especially if sufficient preventive measures have been implemented in the workplace, of course. So as an illustration, at the beginning of March 2020, a dozen Ontario workers had refused to work in a streetcar repair shop out of fear that streetcars were not sufficiently disinfected, and the Ministry of Labour investigated and ruled that the measures in place were sufficient for the workers to resume working the next morning. So it must be kept in mind then that to result in a substantiated right of work refusal, the circumstances must expose the worker to an immediate threat. In terms of the COVID-19 situation, it could be the case, for example, in positions where employees would be required to have sustained physical contact with an infected person without being provided with personal protective equipment. If a worker believes that carrying out their work is unsafe, they must advise their supervisor of the situation and of their reasons to believe that there is a threat to their health and safety or those of others in the workplace. Of course, the union and the workplace health and safety representatives will have to be involved where applicable. The supervisor must then complete a reasonable investigation. The worker may be displaced to other work in the meantime or replaced if the threat appears to be relating to the individual only. The worker is deemed to be at work and, of course, paid accordingly until the situation is resolved. If the situation is not resolved, the local health and safety, Ministry of Labor, or workers' compensation authorities will be called in depending on applicable provincial regulations, to determine whether the working conditions present a threat. They will rule on whether and how the work may still be performed.
Kathleen, we know that prevention is the best medicine, and especially in these times, employers are looking to take measures to prevent work refusals in the first place. Do you have any tips or insights with respect to how employers can do that?
Well, then, keeping your employees informed on how the virus is transmitted and informing them of the measures implemented to protect them is key to reassuring your employees and limit unsubstantiated work refusals. First, a distinction must be made with situations where a work refusal is based on the worker's own health condition. For example, if the employee is immunosuppressed or pregnant or is 7 years old and over. An employer should be proactive in informing employees who present these specific conditions and reassigning them to teleworking where possible or to activities where they won't be in contact with the public. A leave could also be available under provincial jurisdiction. The work refusal would, of course, be unrelated to the specific circumstances under which the work is normally being performed. To prevent unsubstantiated work refusal, organizations should implement all measures recommended by the public health authorities, including denying access to the workplace to employees who should self-isolate because they're coming back from abroad or have flu symptoms or live in the same household as someone who is in self-isolation. Implementing social distancing measures by ensuring that a 2-meter distance is maintained between individuals at work at all times, ensuring access to hand washing facilities, and promoting frequent hand washing, especially when arriving at the workplace and before and after breaks, reducing gatherings to a minimum, including during lunchtime and breaks, and increasing the frequency of disinfection in common areas. As mentioned, employees should be informed of how the virus can be transmitted as new information arises, of what measures are implemented to protect them, and how these measures are mandatory for everyone in the workplace. And of course, supervisors should also be sensitized to intervene when the measures are not respected. Organizations should designate a knowledgeable point person to address employees' concerns and suggestions, to act proactively, and answer concerns as soon as they arise. Finally, we also recommend organizations to remain aware of what comparable businesses are implementing as additional preventive measures or trade associations are recommending, and see whether they may reasonably adopt them as well. Of course, these measures are all industry-specific, but the basic rules exposed before may be transferred in all workplaces. As an illustration of a substantiated right of work refusal under the current COVID-19 circumstances, on construction sites in the province of Quebec, some workers have successfully exercised the right of work refusal last month, since their working conditions did not allow them to respect social distancing and hand washing guidelines. This has led employers to add more trailers for lunch breaks and restrooms for hand washing. Shared tools also had to be disinfected more often as well.
Kathleen, thank you for those important and practical tips. My final question is this: how broadly defined is the right to refuse work in terms of who can refuse? Does the right to refuse work available to all workers?
Yeah, Dan, it's a question I hear often. Actually, the right to refuse to perform unsafe work is limited in most Canadian jurisdictions if exercising such right would immediately endanger the life, health, safety, or physical well-being of others. In most jurisdictions, it is also not accessible to a worker if the conditions are part of the type of work they usually perform. As such, police officers, fire officers, and certain healthcare professionals, among others, cannot exercise a work refusal right in certain jurisdictions. As an illustration, healthcare personnel, if they are adequately protected, could not exercise such rights in most jurisdictions.
Our next presenter is Michelle Henry. Michelle is a partner in our Toronto office, and Michelle is going to be talking to us about employment insurance and the new CERB benefit. So welcome, Michelle. And with all of the measures that employers are having to take, they're of course concerned with what benefits are available to their employees. Can you please start by explaining to us what employment insurance benefits are available to employees?
Okay, thanks, Dan. So the regular EI benefits and sick benefits have not changed much. The reality is that most employers really never turn their mind to it because in most cases they were dealing with a termination. But now that we're dealing with layoffs, many of our clients are asking questions in terms of what the entitlement is. So the entitlement remains the same for regular benefits. Employees will get 55% of their earnings to a maximum of $573 per week. And that is available to any employee who's lost their job or who's been laid off through no fault of their own and who've met the number of insurable hours over the last 12 months. The number of insurable hours also has not changed, and it continues to vary from 420 hours to 700 hours, depending on the area and the employment rate in that area. So, for instance, in Toronto, we're at the high end of 700 hours, insurable hours. So the employee would have to have met that in order to get the benefits. The sick benefits also stay the same. So these are, if we can move to the next slide, these are sick benefits which are available for a period of up to 15 weeks. The insurable hour threshold remains the same at 1,600 hours. The government has now made a couple of changes to that where there's no medical certificate required and also has waived the waiting period of 1 week. So the employees would be entitled to it from the first week. So these are the regular benefits which continue to be available to employees.
Thanks. We've had a lot of questions from employers about whether or not there's anything more they can do. Are employers able to top up these EI payments that you just described?
Yes, absolutely. So it is available to employers to provide some kind of additional remuneration to employees. But in order for employees to get the full benefit of the additional payment, what we are doing is recommending that employers register what's called a supplementary unemployment benefit plan. And this could be done through Service Canada. And what it allows employers to do is it allows employers to compensate employees for up to 95% of their regular weekly earnings under that plan. So, for example, if an employee was making $1,000 per week in normal circumstances, and the employee is receiving the maximum of $573 EI, the sub payment can max out at $377. So that takes them to the 95% max, and that allows them to get both the additional payment without it impacting their employment insurance payments.
Thank you. And from the employee perspective, can employees work reduced hours while receiving employment insurance benefits?
Yes, Dan, this is a very common question we are getting from employers who are continuing to operate and who may not have the same number of available hours for employees but may have work for a couple of days. So the short answer is yes, an employer can continue to provide hours to the employee, and the employee is allowed to maintain the status of working while on claim, meaning they are receiving part of the EI benefits and also earning some amount on their job. The general rule is that the claimant will keep 50% on the dollar when they are earning less than 90% of their weekly earnings. And when you get past the 90%, then you're essentially, it's dollar for dollar. So if we go back to the example of $1,000 per week, if the employee is working, say, 3 days per week and earning $600, ordinarily, that person would have maxed out at $573 on the EI. What would happen in that case is the employee will then have a deduction of $300 off of their EI. So they will get the $600 from their employer, but from EI they will only receive $273. If we go to the next slide, one of the programs that is available to employers. It's called a work sharing program. And this is a program that has been around for a number of years. And there have been some adjustments to it, but the premise of it remains the same. What it allows employers to do is to allow employees to work without having any impact on the EI benefit. So if the program is registered through Service Canada through an agreement with the employee, then that's a program that really provides additional benefit for the employee. We've been advised by Service Canada that the program has now been streamlined, so it is available within 10 calendar days. So if you register and it gets approved, then it's essentially effective within 10 calendar days of that application.
Thank you. One of the new measures that's been getting a lot of press, of course, is the new Canada Emergency Response Benefit. Can you describe that program to us, please?
Yes, so this is a new benefit that we've heard quite a bit about over the last few days. And the government has indicated that it will make available $2,000 per month to employees, and the benefit will continue for a maximum of 16 weeks. It is available. The threshold is much lower than EI, as you can see. It's available to any employee over the age of 15 who's earned income of at least $5,000 in 2019 or over the last 12 months. So it's a pretty low threshold in terms of qualifying for it. In terms of who it's available to, if we can go to the next slide, it is available to anyone who stopped working as a result of COVID-19 and who do not have access to income support. It's available to anyone who became sick or became quarantined or is caring for somebody who's sick. It's available to those of us who are home with kids at home and as a result of school closure or child care facility closures. And it's also available to any kind of self-employed or contingent worker who otherwise would not have qualified for employment insurance benefits. So it is quite broad in terms of who can be eligible for that benefit.
Thank you very much, Michelle.
Thank you.
Our final presenter is Duncan Marsden. Duncan's a partner in our Calgary office. And you'll have heard from a number of our previous presenters references to leaves and how the leaves impact on your organizations. Duncan is going to focus on that and take us through both the general leaves that are available to your employees and new specific leaves that have been enacted across Canada. So, Duncan, maybe you can start off by telling us about the general leaves that are available to employees to be taken in these types of circumstances.
Yeah, thanks, Dan. There are a number of leaves which employees can take as a result of this recent outbreak. And I think part of the difficulty with the COVID-19 outbreak is that employees were being required to take leave when they weren't necessarily sick. In previous circumstances, you would have an employee who is too sick to attend work and they could take sick leave. But the difficulty with the COVID-19 outbreak was that an employee might be required to self-isolate or be in quarantine and might not necessarily be sick at all. And so while there are other leaves which might be available for other circumstances, they weren't necessarily attributable or perfect for this situation. So I'm going to go through the quarantine leaves which have been created in the last couple of weeks by the various provinces. But I wanted to mention at the outset, Dan, that there are a number of leaves which could still apply. And there are some on the screen there, such as critical illness leave, family responsibility leave. So don't forget that even if an employee is required to self-isolate and is away from the workplace as a result of COVID-19 issues, there may be other leaves which apply as well.
Okay, thank you. So can you tell us about some of the new quarantine leaves that have been introduced, please?
Yeah, absolutely, Dan. So the first slide talks about some of the provinces which have not made any changes. And so I think the easiest place to start are the provinces where no specific quarantine leaves have been introduced. And they're on the slide in front of you now. Again, just to reiterate, there may be other leaves which allow employees to take job-protected leave during this pandemic. And these provinces may introduce quarantine leaves at some point in the future, but at the moment they have not introduced those leaves yet. Then if we look at Ontario, Ontario has introduced the infectious disease emergency leave, And this is unpaid job-protected leave. And some of the themes, Dan, that we're going to see throughout this process are the idea that a new leave has been introduced in case an employee was not covered by previous leave, and the idea that provinces have removed the need to to provide a medical note and have removed the length of service requirements, which were sometimes in place for other leaves. So those are the general themes that we're going to be looking at. They're generally job protected and generally unpaid throughout the provinces. So the first one is Ontario, and an employee can claim infectious disease emergency leave if they are under medical investigation, supervision, or treatment for COVID-19, if they're in isolation or quarantine, if the employer directs them to be, and various other reasons as well. In relation to Ontario and some of the other provinces, there is also added commentary that if the employee has to provide care for a person related to a COVID-19 reason, and that includes daycares or schools being closed, or if the employee is prevented from returning to Ontario because of travel restrictions, then they're also entitled to take the leave in those circumstances. And other provinces have followed suit with respect to that. In Ontario, the leave lasts for as long as the employee is not performing the duties because of these situations. And again, as previously mentioned, the employee is not required to provide a medical note, although the employer may require the employee to provide other evidence that's reasonable in the circumstances. It's also important to note that these measures in Ontario are retroactive to January the 25th, 2020, which is the date that the first presumptive COVID-19 case was confirmed in Ontario, and they're going to remain in place until COVID-19 is defeated.
Thank you, Duncan. Have there been any specific leaves enacted in your home province of Alberta?
Yes, Dan. So with respect to Alberta, there is quarantine leave of up to 14 days, and again, it is unpaid and job protected. Again, employees are not required to give any written notice, and they're exempt from length of service and medical notice requirements. In Alberta, there may also be emergency isolation support payments or a one-time payment of $1,146 in certain circumstances.
And can you walk us through any new leaves in British Columbia, please?
Absolutely, Dan. So in British Columbia, there is, again, a quarantine leave which has been introduced. Again, it's for individuals who are, or employees rather, who are diagnosed with COVID-19 or who are in quarantine or self-isolation or directed by their employer to stay home. And similar to Ontario, there are provisions relating to the care of a minor child or a dependent adult, or individuals who are unable to return to British Columbia because of a travel or border restriction. Similar to Ontario, the length of the leave is as long as someone is unable to work due to one of the reasons. And again, a doctor's note is not required, but the employee may need to give reasonable evidence of eligibility if the employer requests it. This leave is retroactive to January the 27th, when the first presumptive COVID-19 case was confirmed in BC. In BC, there is an emergency benefit payment, a one-time payment of $1,000 to people who lost income because of COVID-19.
Thank you. And finally, I see that we have a lot of attendees who are from federally regulated workplaces. Are there any particular new leaves that they should know about?
There are, Dan. There are two leaves, in fact. There's quarantine leave and leave related to COVID-19. They both last for 16 weeks, and the difference really is that with respect to quarantine leave, a certificate by a health practitioner is not required, but with respect to leave related to COVID-19, the employer may require an employee to provide a written declaration in support of the reasons for the leave. The reasons for the leave with respect to COVID-19 are generally that the employee is unable to attend work or is unavailable for work for reasons related to the coronavirus outbreak. And so that's quite a wide definition there.
Thank you very much, Duncan. Thank you very much for joining us today. We trust that the information we have provided you is helpful to assist you and your employees during this challenging time. If you have any questions regarding any of the issues our speakers covered or any others, please reach out to any of us or your usual legal advisors. As we have heard today, the laws and measures across Canada are rapidly evolving, literally day by day. So we will, of course, stay in touch with you, and please look for further webinars, updates, and bulletins from us to help support you, your organizations, and your employees. Thank you, and most of all, be well.